Judgment in the matter of the Crown on the application of Jwanczuk against Secretary of State for work and pensions.
Lady Simler will explain the decision of the Court.
This appeal concerns bereavement support payment, or BSP, which is a non-means tested social security benefit, providing financial help to people whose spouse or partner has died. It is only paid to the surviving spouse or partner if conditions specified in the Pensions Act 2014 are met. These include what I will refer to as the contribution condition in sections 30 and 31 of that Act. These require that the deceased spouse or partner has paid relevant national insurance contributions for at least one tax year during their working life. Mr. Jwanczuk applied for BSP following the death of his wife, Suzanne Jwanczuk. She had a progressive degenerative condition that meant she was severely disabled. During her working life, Mrs. Jwanczuk was never in employment and never paid any relevant national insurance contributions. Mr. Jwanczuk's claim for BSP was therefore refused because the contribution condition was not met, and he then challenged that refusal by judicial review. He claimed that his wife was unable to work due to her disability and that applying the contribution condition in these circumstances constituted unlawful discrimination in breach of Article 14, read with Article 1 of the First Protocol to the European Convention on Human Rights. Mr. Jwanczuk relied on the 2020 decision in O'Donnell against Department for Communities, which I'll refer to as O'Donnell for short. In that case, the Northern Ireland Court of Appeal held that the contribution condition in the materially identical Northern Ireland pensions legislation unlawfully discriminated against the surviving spouse or partner of a deceased person who'd been unable to work due to their disability, and that an exception had therefore to be read into the legislation in order to cater for such cases. Mr. Jwanczuk's claim in this jurisdiction succeeded in the High Court and the Court of Appeal of England and Wales. Both courts considered that they should follow O'Donnell unless it was clearly wrong or there was a sufficiently compelling reason to depart from it. The Secretary of State's appeal to the Supreme Court raises two main issues. The first is how the appellate courts in the 3 UK jurisdictions treat decisions of coordinate jurisdiction on the effect of similar or materially identical legislation. The second is whether the contribution condition unlawfully discriminates against Mr. Jwanczuk. In a joint judgment given by me and Lord Reid, with whom Lord Lloyd-Jones, Lady Rose and Lord Richards agree, we unanimously allow the Secretary of State's appeal. On the first issue, we hold that the answer is governed by rules of practice based on comity and good sense, and not by the law of precedent. This means that the decisions of the appellate courts of England and Wales, Scotland and Northern Ireland should be treated as persuasive authority when a similar legal point arises in one of the other UK jurisdictions. The precise weight to be attached to them depends on a range of factors and involves the exercise of judgment. For example, the courts have taken a strict approach to decisions about the interpretation of tax legislation, reflecting the constitutional and economic importance of the uniform application of tax legislation across the UK as a whole. But the approach to decisions concerning the interpretation of legislation on other topics is not so strict. On the one hand, it is undesirable that there should be conflicting decisions on the interpretation of provisions which are intended to apply in the same way in more than one UK jurisdiction. But on the other, the appellate courts are not obliged to follow decisions they consider to be wrong. In any event, appellate courts are not required to identify a compelling reason or exceptional circumstances to justify disagreement with the decision of another UK appellate court. Rather, they should explain why they consider the previous decision to be incorrect, give what they consider to be the correct decision, and grant permission to appeal to the Supreme Court so that the difference of views can be resolved without delay. Here, the Court of Appeal of England and Wales should have departed from O'Donnell if it considered that decision to be wrong. There were good reasons for the court to do so. First, the Secretary of State chose not to change the approach to BSP for England and Wales after the decision in O'Donnell, indicating that consistency in the different jurisdictions was not seen as a matter of overriding practical importance. Secondly, in 2021, and after the decision in O'Donnell, the Supreme Court handed down an important judgment which was relied on in the courts below in this case, but obviously couldn't have been relied on in O'Donnell. Thirdly, not following O'Donnell would simply have maintained the status quo. On the second issue, the substance of Mr. Jwanczuk's claim of unlawful discrimination, we hold that he has a protected status within the meaning of Article 14 of the Convention, on the basis of which he should not be treated adversely in relation to BSP. That is because disability is recognised as a protected status, and disability was a factor in the reason why Mr. Jwanczuk, who was associated with Mrs. Jwanczuk through his marriage to her, was refused BSP. We reject the argument that Mr. Jwanczuk's status is too subjective or too susceptible to change to qualify for Article 14 protection. The Secretary of State in this case does not dispute that social security benefits can be possessions, and that a decision to refuse BSP falls within the ambit of the first protocol to the Convention, which protects the right to peaceful enjoyment of possessions. The next step is to consider the nature of the discrimination claim put forward. Unlawful discrimination can arise where, without sufficient justification, peoples whose situations are materially different are treated in the same way. Mr. Jwanczuk argues that the refusal of BSP in this case meant that he was treated in the same way as any bereaved person whose deceased spouse or partner made no national insurance contributions for reasons other than severe disability, for example, because they simply didn't wish to work. He alleges discrimination because of the failure to treat his situation differently on account of his deceased wife's severe disability that meant she was never in employment and never paid any relevant national insurance contributions. And he says that an exception should have been made on that basis. We conclude that the failure to treat Mr. Jwanczuk differently by making an exception to the requirement to meet the contribution condition in this case is objectively justified. In reaching that conclusion, we apply the test established in a well-known case known as Bank Melhat. In doing so, we note that the contribution condition has three aims. First, to encourage people to work to make the contributions needed to obtain contributory benefits such as BSP, reducing the stigma of claiming benefits. Second, to simplify the benefit system to reduce administrative cost and complexity. And thirdly, to ensure greater certainty so that individuals understand what they're entitled to and can plan for the future. All three aims are legitimate and rationally connected to the imposition of the contribution condition, which we conclude is justified and strikes a fair balance between the rights of individuals affected by the measure and the interests of the community as a whole. This is a case where Parliament should be given a wide margin of appreciation because it concerns primary legislation in the socio-economic sphere and political choices about how to allocate scarce public resources. Furthermore, the contribution condition was enacted in the 2014 Act following a consultation in which the impact of that condition on disabled people was expressly considered, and the decision was made not to make an exception for people in Mr. Jwanczuk's position. This was an exercise of political judgment, and the court should be very slow to substitute their own view for that of Parliament in these circumstances. We therefore allow the Secretary of State's appeal and hold that Mr. Jwanczuk is not entitled to BSP because the contribution condition is not met and did not operate in an unlawfully discriminatory way. The result may seem harsh, and the Supreme Court does not underestimate the vulnerability of people in Mrs. Jwanczuk's position or the difficulties faced by their families. However, the courts, including the Supreme Court, must respect the boundaries between legality and the political process. We find no proper basis consistent with the separation of powers on which to overturn Parliament's judgment here.
The court will adjourn.